And on behalf of the sponsoring organizations that are listed on the screen and the host law firm, welcome to Denver's first jury improvement lunch. Here's the problem. There are fewer civil trials today, both bench and jury, than at any point in time in American history. In 1962, the year most statistics on federal trials became available, roughly 6% of the civil terminations were by bench trial and 5.7% by jury trial. So roughly 6% by trial of some sort. And when you talk about the percentage of dispositions, that takes account for either an increase in filings or decrease in filings. The percentage should remain constant, one would think. In any event, by 2016, last year, that number has fallen to around 0.7%, which means that federal judges, on the average, are trying less than 2.6 jury trials and 1 bench trial per year. And by the way, for those critics who say, well, the reason jury trials are disappearing is that they are too expensive and we can't trust juries. How do they explain the fact that bench trials have fallen quicker than jury trials? I didn't know this when I was instrumental in setting up the Civil Jury Project. If I had, I would have called it the Civil Trial Project. Because the problem, folks, is we are losing public dispute resolution altogether. The most recent data on federal courts in Colorado, and this just shows the average number of trials per judgeships. In Colorado, the statistics show the same decline in the federal bench. The good news here is that your federal judges per authorized judgeship are trying 6 on average jury cases per year, which ranks them 5th in the nation in productivity in trying jury cases among all the federal district courts. Well, that's a pretty good accolade. And maybe explains why so many people are here for this lunch today. And as you can see, but the same pattern of a decline in both jury trials and bench trials. In your state district courts, the pattern, although the data only begins in 2001, the data is almost the same kind of trend line. In 2001, 8.8% of cases were tried, disposed of by jury trials. That's down to 0.3%. So this is the problem. And to deal with this problem, the Civil Jury Project was established at NYU several years ago as the only academic center in the country devoted exclusively to asking the question, why is the jury trial, which was so important to our founding fathers that they mentioned it in the Declaration of Independence, in Article 3 of the Constitution, and 3 of the Bill of Rights, and every state constitution in 1791, when the 7th Amendment was adopted, guaranteed the right to trial by jury of civil cases. So why is this treasured institution in such disuse today? The jury has been such an integral part of the architecture of the American justice system that there's not a courtroom in this country that doesn't have a jury box in it. And so the question is, we know what's happening. Is it worth complaining about? Should we be concerned? And if we should be concerned, why? Because a lot of people, including a lot of judges, think, well, is this such a bad idea? I got an email this morning from a judge who came, we had a lunch just like this in Kansas City yesterday. 150 lawyers were there. A federal judge from Kansas City, who's been on the bench for 2 years, I had never met her before. She slipped in to the meeting and wrote me an email early this morning that said, it was a great luncheon. She thought it was important to have luncheons like this. But she says, does it really matter that we're losing jury trials if there are other fair ways to resolve disputes? And that caused there to be, then I involved 2 other federal district judges, Judge Martin from Wichita and Judge Booth from Kansas City in the conversation. And we persuaded her by about 10:30 that it does matter. I mean, it was just a matter of communication and dialogue about why this, and my point to her, which I think is the most, imagine to our founding fathers, before we kiss it goodbye, let's figure out what they were concerned about. And what they were concerned about was being before fair judges, because the king in those days was appointed the judges. They were concerned that being the 12 citizens there before they could take your liberty or your property was the best protection of all the other rights. And that's why they insisted on the 7th Amendment of preserving the right to jury trial. The founding fathers knew jury trials were more expensive than bench trials. They knew jury trials were more subject to eloquent lawyer advocacy, to emotional responses by the jurors. And yet they wanted jury trials because they wanted to protect the little guy against the powerful. Powerful businesses, powerful creditors, and a strong central government. In this country today, 90% of cases are tried by state judges who are elected. The empirical evidence all shows that elected judges tend to favor those whom they view as responsible or potentially responsible for their staying on the bench. It's not obvious, but it's there. There is not, in spite of all the talk about abandoning the election of judges, not one state that has adopted election of judges. It was adopted in the early 19th centuries, prior to Jacksonian democracy. Not one state has gone backwards. So we aren't going to give up in this country the election of judges. And as long as there are elected judges who are allowed to solicit contributions from litigants appearing before them, the people of America need juries. And we ought to be real careful before we say, there are other ways to resolve disputes. In any event, let me mention what our project has accomplished in the last few years. We have created and maintained 2 websites, and our first website is a website primarily for lawyers, judges, and academics. We have 250 judicial advisors, 65 academic advisors, law professors, political science, university professors who have studied jury behavior, the history of the jury. And then we also have over 40 now jury consultant advisors who help us with our programs. And this is, on this website, I listed our projects and what we are doing with them. And there's a lot of material for you. I wish you go there. And we have conducted empirical research on a lot of subjects, including how jurors react to the various innovations that have been suggested for improving jury trials. Spreading the word, we took a poll of the public recently, and we discovered that 80% of the non-lawyers in this country think that jury trials have either increased or remained steady in the last decade. So a very small proportion of Americans are aware of the graphs I showed you. They watch television, they go to movies, they think trials are healthy. They just think the courthouses are busy. Those of us who've been to courthouses recently, particularly federal courthouses in this country, know that they are like marble mausoleums. You can shoot a cannon down the hallway and not hit anyone on a Wednesday afternoon. So, and that's one of the reasons we are in such danger of losing jury trials, because when you tell those people in the survey we took that they are guaranteed trial by jury by the Constitution of the United States, they get very upset. when they learned that the trials have actually been declining in the last decade. We have been around the country trying to host lunches like this. This is our 10th jury improvement lunch. We are holding 8 this fall. We had one in Kansas City yesterday. Next week we are supposed to be in Cleveland. We go to Cleveland. We've been everywhere. Cleveland, Oklahoma City, Seattle, Boston, Dallas, Houston, Corpus Christi. And the idea here is that we want the lawyers and the judges to talk to people who serve on juries, to learn what we can do to improve the system, to thank our jurors for having served, and to, but it's local option. We will have, you've had your first here, the next one's up to you. By the time you get to your offices this afternoon, you'll have a survey that will ask you whether you want to, would you like to attend one of these again? If so, how often Denver should hold them, what the subject should be, what the format should be, and then there's a place you can volunteer to be on a planning committee. We'll turn the names of the planning committee over to the organizations that were sponsors of this event today, the law firms that hosted it, and take it from there. And hopefully we will get something like this started on a regular basis in our communities. My hope initially was that we could do one of these every month, on the fixed day of every month. And it'd be really successful because lawyers like us in trial cases, we don't have a place to go eat lunch and talk to judges and talk to jurors. It'd be a great institution if we could do it. Unfortunately, there are not enough jurors being discharged to come to lawyers like that. We only have 3 that are here today. And so you need more time. We've also found at the lunches we have that if you get a juror who served 2, if the service was not recent enough, they forget what it was they liked and didn't like about the trial. And they know that parking was ridiculous, they had paid for it, and the cookies were bad. But when it comes time to what went on in the courtroom, their memory's not exactly sharp on that. So we need to get them pretty quickly after they serve. Another problem we have with getting jurors is that we have to assure the litigants and the judges who we have to depend on to invite the jurors, that the jurors will be instructed and will obey the instructions, not to talk about the evidence in particular cases, not to mention the names of particular judges or jurors, and not to disclose what went on in their deliberations. We are interested in improving the process, not analyzing the particulars of a given case, because if the case is still going on, no one wants to open the black box and cause some kind of motion for a new trial based on jury misconduct. So the jurors who are here today have been given that warning. They were doing it in advance, they're giving it again now. And what we are looking for, and I ask the judges and lawyers, if you want to do this again, it would be a great idea. Look for an important or significant or complex civil case in this community that's tried, jury returns a verdict, and then gets settled. That is the ideal case to do a post-mortem on. Because you can invite all the jurors, the judge can come, and the lawyers on both sides, and people can talk freely about what went on during the trial, what went on during deliberation. Then we can really learn something. But obviously, when you see a trial like that, you'll have to throw together a lunch like this very quickly and get the invitations out. We publish a monthly newsletter, which you should have received in November's already. The others are on our website. We maintain a second website, which is called WeThePeopleWeTheJury.com. And this is for jurors only, potential jurors and former jurors. And as you can see, when they go to this website, they have 3 choices. Served on jury duty before. You would check that. Once you hit that button down here on the right, you are taken to a questionnaire, and you're asked to fill it out. We've had hundreds of jurors go there. They get there by receiving a card like this, which the judges are all given. We're trying to distribute to judges throughout the country. They give this card to every juror they discharge. which says if you want to talk about your experience, you don't have to. But if you want to blog about it, go to the website. Hundreds have come to this website. 98% of them are complimentary. When we find jurors who are articulate and who loved it, we rush a videographer to their community. We take a video testimonial, and then all the raving about how great jury service was is put on guess what button? Received a jury summons. Now people get to this website who have received a summons by surfing the web, looking for a way to get out of jury duty. And they will come, if you surf the web, they will come to our social media presence, which is here. And this is a very active, we get a lot of tweets and we monitor how active this is. And we post a lot of stuff. And when we post them here, we try to send them. They're looking for a way to get out, but they go to our website. When they click that left-hand button, they immediately see judges and former jurors say, don't throw away your summons. You're about to have the best experience in your life. Go to the court and report. It's your civic duty. It's the only way you as a citizen will ever be you are a government official when you are a juror. It's the only time in your life you'll be an official of the government, making governmental decisions. So go. We hope, we have not been able to do any research, but we hope we can increase the yield of jury summons by sending the people who receive the summons to a place where they hear praises about jury service. Today our focus is on improving the affordability and reliability of jury trials. There are clearly alternate ways of resolving disputes. The most prominent being confidential arbitration using private judges. There is no alternative way of exposing ordinary citizens to how the legal system works or empowering them to play an important role as decision makers. Three of them are here today for themselves, and they can speak for themselves. Now, not here today are the many repeat users of this public dispute resolution system. But we have conducted an empirical research, a recent study, where we went to the filings of material contracts, business-to-business contracts by publicly held companies with the SEC in a 6-month period of time last year. We looked at over 5,000 contracts, and we looked to see what percentage of those contracts include a jury waiver or mandatory arbitration clause. It's high, 43%, but not as high as I expected. The majority of American, at 47%, the majority of American companies still are willing to trust their disputes, with big business-to-business disputes, to public dispute resolution by jury trials. So we're doing two things. Richard here today. Richard is our research fellow. He's here, but he must be outside. He and I are contacting the general counsel of those companies who do not have jury waivers, arbitration clauses, and say, well, hey, what happened? Is this a mistake, or was it intentional? And we're getting a lot of great testimonials from them about the horrors of arbitration. It's too expensive, it's too slow, there are no appellate rights, on and on, which is great too. And then on the other hand, what we're doing is putting our program focus to how can we improve the jury trials we do have so that the 43% of repeat users have better faith in the ability of juries to get it right. And we have written articles on all these innovations that have been tried for a long time. Well, they've been suggested on the books for a long time, but not many of them are actually used. Now, I'm going to ask, at this point, I ask the judges and the jurors who are here to come up, and we would ask Judge Arguello to make a few welcoming remarks before I begin questioning our panel. So Judge Arguello, and could Judge Jones, Judge Jackson, Judge McGahee and Judge Goldberg come forward.
Well, let's give a hand for what's the work that Steve Sussman is doing in this area. I have the privilege of actually going to New York in early September to sit on a judicial panel with Professor Sussman's group, and I've learned so much from that as well. So I want to welcome you all here. I am pleased to see that we have a full house. On behalf of the federal judiciary, I welcome you, and I know Judge Jackson is here. I saw Judge Mix, and I think I saw Judge Wong. Is anybody else here from the federal court? Okay, and I see a bunch of state court judges here, so it's good to be here. I hope we will learn something. I have 2 jurors from a trial I recently had, and I just want to say something. I think our numbers at the federal court are up in terms of trials because of Judge Jackson. He kind of like doubles what all the rest of us do. So, I'm going to imitate him so that we go to trial more often. Anyway, with that, Steve, I'll turn it over to you.
Let me begin by asking our jurors, we have 2 jurors that sat on a federal trial in your court, different trials, but 2 different separate cases.
No,
Same case. And then we have a juror that sat on a state court civil trial. These are rather short trials, I understand, 3 or 4 days. And so I have already sufficiently led the witnesses. But let me ask you, before we begin, what did you think about it? Did you enjoy the experience? Would you want to do it again?
I did enjoy it, and I wouldn't want to do it again. What you said was right on. I mean, everybody tries to get out of it, and it was a great experience.
What can we do to make it better? What can we judges and lawyers? What's your biggest complaint? Give me your biggest single complaint. And don't make it cookies or parking.
No, I did get free parking. I have no idea. I don't know how to make it better.
Okay. When you got a summons, when you got a summons, were you happy or sad?
I was sad because I did have a lot of things on my calendar and there wasn't a lot of notice. I have a second home in Summit County and I had just gotten the notice up there, and so I was really proud of myself for being able to get out of that. And immediately I got so but the other 5 jurors, I think they had a whole lot more going on, and I was okay. And in the end, I really did enjoy it.
All right, and Miss, you pronounce your name? Weiss. How about your experience?
I thought it was overall very
Pull the mic over to you a little bit.
I thought it was overall very positive. I was coming in expecting the worst.
Pull the mic a little closer to you so everyone can hear. Thank you.
I kind of had the expected response. Oh goodness, I really want to do this. But I ended up actually walking away with pretty good things to say. And my coworkers, of course, how did they want to know what it was like? So I kind of shared that experience as well.
And Ms. Frederickson.
When I got the notice, I thought I really don't want to drive to Denver. So I was real happy to find out that there was a way that I could stay here for the duration of the trial. I thought the selection process was pretty clear. It kept you informed. She ran a really tight ship and kept us stepping. So I thought the whole process was.
In your case, did the judge allow the lawyers to ask any questions during jury selection?
Yes.
The judges The lawyers participated.
Yes.
Did you think their questions were stupid, or were they good questions, or did they invade your privacy? Do you think they were too invasive of your privacy? What do you think about the lawyers who were answering the question?
I think the questions that they were asking, they were trying to find jurors favorable to their position, whether it was the plaintiff or defense. If they, I mean, that's the whole purpose, I think, is to get people on the jury that the attorney thinks will be favorable to their client.
Do you think that they asked the right questions to discover, in your case, whether you'd be for or against them?
I think they missed something in my case.
That's hard enough.
Even though I am one of the questions the judge asked, I disclosed it. I don't think either one of the attorneys picked up on it, but
Ms. Kane, did you lawyers ask questions of you or judges?
The attorneys
The attorneys did. And do you think they asked the right questions to discover whether you had any hidden biases? I think they coined the term.
I think they did.
Did it trouble you? Did you think they were too argumentative when they were questioning, or were they just trying to get information?
Just trying to get information. It's pretty simple.
It's fine.
Yeah, I think they were asking for their questions, and I think we got a couple people who had insurance biases, and it was an insurance case, so I think they found what they were looking for. I'm in the medical field, so I think they chose me because of some of the medical things that were going on with the case, so, yeah.
Now, you all had fairly short cases, 3 days. Did the judge tell you at the beginning how long the case was going to go?
In a sense.
So you knew in advance pretty much how long?
it was actually, we finished sooner than she thought we would, so.
Let me ask the judges now, I'll turn to the judges, and we'll go back and forth, because then I'll find out what some of these judges did. Number one, how many judges allowed jurors to, the lawyers to participate in voir dire? Okay, so it's unanimous here. And this is something to the lawyers I've learned going around the country. I believe.
Doesn't mean they're very good at it.
Well, everyone here understands that what happened is the lawyers were terrible at it. There's an explanation for that. The lawyers were terrible at it. And in my state was worse. I'm from Texas. I mean, they taught me as a trial lawyer, you didn't win your case. We call it voir dire. You didn't win your case in voir dire. You weren't going to win your case. So we got up there and argued our case. That's how we were taught. And we were so bad, so abusive in doing it, that the federal judges all around the country, about a decade or so ago, took the privilege away from us altogether. And it's only in recent years that we are behaving, that we are regaining access to that participation. I believe about 50% of the federal judges around the country will allow the lawyers some limited, up to 30 minutes, voir dire. And the lawyers will tell you that's very important because some judges are great at it, and some judges are very perfunctory at it, as all these judges know. One of the things that is suggested in a 3-day trial doesn't have any problems like that, but one of the things that has been suggested as an innovation is that trials be time limited. Certainly if we're going to go more than 5 days, the judge should set a limit on the time, divide the time, tell the lawyers exactly how many hours they go on each side, so that the jurors can know exactly.
Is this not an explanation of why people view public dispute resolution as so expensive? I mean, I know in my firm's case, we get a case up in trial, it never goes to trial the first setting, or the second, or the third. And finally, you just look at your client and say, Lordy, there's got to be a better way and a cheaper way to do this than get geared up 4 or 5 different times for a trial that does not go
So, how about it, judges? Do you tell the lawyers early on when their trial is gonna be set? Judge Goldberg?
Yeah, I'm a little different than my colleagues up here. I believe in active case management, and that's including them through the trial. We have 6 jury trials scheduled every Monday. And in order to ensure that the trials go and in compliance with Chief Justice Directive CJD 08, which is Nancy Rice's directive that all cases be tried within 365 days, we let them know the time they're going to have. It appears that somebody's going to use that time. My law clerk and I both have chest locks on our phones, and we use them. And we make sure that we manage, and they're free to talk to us about the time remaining and the like, but I'm also cognizant that if they spill over, they're depriving the next judge, the next set of litigants of their time in court, of their day in court. And I'm also cognizant that we have committed to the jurors that we're going to get the case done within a specific time.
Now, and you know, we have, the most frequent complaint I've heard from jurors in the questionnaires and these lunches like this about trials is that the lawyers are too damn repetitive. They ask the same question over and over again. We got it the first time. They didn't have to keep saying and doing the same thing. So that argues for some kind of arbitrary time limits, because as a lawyer I know, and I think most trial lawyers have been told, you have 15 hours, use it however you want. You can use it to play depositions, you can use it to call live witnesses, you can use it to cross-examine the other side, you can even use it to make an argument at the beginning of the case and end of the case. That's the best trials I've ever been in, because I have to plan them as a movie director. You have to really concentrate and focus on what matters and what doesn't matter. And you put up, yes, Judge?
Well, I would like to say, they're not arbitrary time limits. I set time limits, but it's based on what the lawyers estimate, so they're not arbitrary. But my rule is, if you're gonna go longer than a week on a case, and I've looked through it and I don't think it should be, you have to come before me and justify it. And if you can justify it, you'll get your 2 weeks or your 3 weeks. But I do split it evenly. I don't let the defendant get railroaded because plaintiff is taking too long. If you have a week, that's essentially, after I pick the jury that morning, it's about 13 hours, 12 hours each. And I will prod counsel, and I had one case where I let him go for 2 weeks. And plaintiff just spent so much time on their examinations reiterating that I said to them at one point, I said, you only have 4 hours left. And so we have enough to finish our witnesses. I said, you don't want to cross-examine any of the witnesses the defense brings in? And I tell you, they tightened it up and they were able to get it done. So, they're not arbitrary time limits, and I think it is. I think one of our biggest problems from the juror's perspective is we do not show consideration to them. And I served on a 4-week, as a juror on a 4-week criminal trial in state court 3 years after I became a judge, and I learned how inconsiderate we were with them. And it's hard work to be a juror, which is why I said to them, and I will call counsel up and say, what was the last 15 minutes about? It wasn't even relevant, and you didn't object. And I think you have to have that kind of management of your docket.
There's some judges in the country that are banning sidebars.
I don't ban them, but I said, if you have a legal issue, an evidentiary issue, you come in at 7 in the morning, because I'm bringing that jury in at 8, and we are not gonna have sidebars unless they're absolutely necessary, and we normally don't, so I guarantee my jurors that they'll have 6 hours in the chair, and then they go home at 2:30. Because they get out of downtown Denver, and I will tell you, having served on that jury, the jurors aren't hearing anything, they're not absorbing anything you give to them after 2:30 anyway. You've thrown so much at them that they can't absorb anymore, which is why
So
I think being considerate with the jury.
Your hours are what now? What do
We
you
go 8 to 10, take a 15-minute break, and it's truly 15 minutes because we do not do bench conferences or anything like that. We go 10:15 to 12:15, they bring their lunch, and it's a half-hour lunch. They go 12:45 to 2:45, and then they go home for the day. And if we have legal matters, we take care of those afterward or before. And I think it's just more considerate. Also, if I have a trial that goes longer than a week, I pick them a week in advance because it is so inconsiderate to call them in And that's how I felt. I mean, I went to jury duty expecting I would never get selected, to find out I am on a 4-week jury trial, and the only reason I could do it was because I had 2 weeks of vacation. This was over the Christmas holidays. We pick it a week in advance so they can go home and make their arrangements to figure out how they're gonna deal with their kids or their employer. And it works much better that way. I get so many fewer hardship excuses. And I think the jury just sees that I am being very considerate of them and their time. And I think it helps.
Anyone else have experiment with different trial time? Judge Jones?
I require, if it's gonna be longer than a week trial, that they clear it with me in advance. So I have an idea of how long the trial is anticipated. And I don't set time limits, but lawyers always overestimate how long something's gonna take. And so I move it along, and we're very efficient in the way we do our trials. I don't ban sidebars, but you pay for them when you come up to the bench to talk to me, such that we have a lot fewer of them as the trial runs along. And I tell the lawyers in advance, there's my time, there's your time, and there's the important time. That's the jury's time. We won't make them sit in the jury room. We will work before the trial starts. We will work during the breaks. We'll work at lunch. We'll work after they are let go. We do not expect our jurors to do anything but be jurors. And they're not just waiting for things. So as a result, I talk to every one of my jurors or juries, and nobody has complained about us wasting time. They complain that the lawyers are repetitive, but not that their time was wasted. We make good use of their time because we're imposing on them.
Judge Jackson, what's your schedule? What schedule do you work the jury on?
Roughly 9 to 12, roughly 1 or 1:15 to 5.
Okay. And do you have to conduct sidebars or not?
Sure. If they need them.
Do you, Judge Mark Bennett, a federal judge from Iowa, has written about and proposed something called a juror's Bill of Rights. That is the idea that jurors deserve certain rights when they come to court and do the service, like the hours that they work, not to be bored to death, etc., etc. I mean, there's a whole list. And I recently read some retired trial lawyer, so I assume he's even older than I am, wrote a response to that in the Abota, this is in this month's Abota's journal, that said, that's ridiculous. Jurors don't have rights. That's a duty. It's a constitutional duty to serve on a jury. You should not have rights. So what do you think about the jurors' rights? I mean, should jurors have rights?
Jurors have rights to be treated with respect. And if you do that, and if you use a little humor here and there, as Bruce does, I meet with them after every trial. They love the experience. They say they're glad they did it because you treated them right. It's just a matter of respect for them and their time. And there are a lot of things that go into that. Not too much repetition, not speaking down to them, joking with them. My wife makes them muffins.
A innovation that is talked about a lot these days, and that was initially suggested almost 20 years ago, is that we should be instructing the jury on what the law is at the beginning of the case, not at the end of the case. In every other, there's a very funny, it's not actually funny, it's a pathetic movie that was made in 1998
Association of Defense Counsel called Order in the Classroom. And it's a movie, it's like a 10, you can get it, you can go on Google, YouTube, Order in the Classroom. Look at it, you will laugh. But it's a college professor coming in talking to a bunch of college students. He said, this is going to be unlike any other class you've ever been to. I can't tell you how long it's going to last. Can't tell you how many lectures it will be. I can't even tell you what the lectures are going to be about. I can't tell you what's going to be on the final exam. You can't ask questions. You can't discuss with each other what we talk about in class. And on and on and on. And, you know, and we aren't going to even tell you what the rules are till you see them on the exam. So then the class, at every one of these announcements, the students look amazed, and then, let's get going, you will find this interesting. But the point is that we, in some ways, handicap jurors by not telling what the law is at the beginning of the case. Has anyone experimented with preliminary substantive instruction?
I will tell you that I've got a trial going on right now, as you know. At 1:30, I disappeared. It's a 2-week trial. Trade secrets, big companies on both sides, plaintiff received $190 million. I instructed the jury fully. General instructions, elements, damages, the works, right after jury selection.
Judge McGahey?
Well, I don't know a Colorado State judge who doesn't do that. We have a script that,
Now, wait a second, I'm not talking about just the burden of proof.
no. I mean, I agree with Brooke that you give them yes, you give them those generalized
Yes.
instruction because they need to know what they're gonna do. But you can also give them the elements of whatever this is a legal malpractice case. For the plaintiff to win, the plaintiff has to prove blah, 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 blah. Why not tell them in advance? I don't know about how my colleagues do it, but certainly when I'm in criminal, I do always tell a jury right up front, this is a first-degree murder case. To prove first-degree murder, you gotta show this, and this. Why not do it in a civil case too? I do it.
Judge Goldberg?
Now, I'm hesitant. We have general instructions regarding credibility and the preponderance or the burden of proof, but I'm never sure what claims are going to survive a Rule 50 motion and ultimately make it to a jury. Similarly, I'm not sure whether or not there's a factual basis for an affirmative defense. So I'm concerned or leery about charging the jury with those instructions before, because I think it may prejudice or impact the trial or one of the sides.
Okay. Well, let me play the devil's advocate, that's what I'm supposed to do here. Is, yes, things may drop out of the case, but you just tell the jury at the beginning, I'm going to instruct them on things that may become irrelevant because theory of loss and things drop out. But I'm going to instruct you again at the end. Those are the ones that really count. But other than that, just having to waste, I mean, my gut reaction observing a lot of trials is that lawyers don't like that because they don't want to do the work early. They really don't, they're lazy. And judges don't like it because they don't want to do the work unnecessarily, which is what your objection is. Jurors, would you think it would be helpful to know before you heard the evidence what the plaintiff had to prove to win?
I think so. I mean, you're sitting in this trial, you're getting all this information thrown at you. You've got to know some of it is erroneous, some of it is really important. You should know what you should pay attention to instead of trying to sift through everything at the end. My opinion.
Okay, let me switch to, I got a lot of innovations to cover, so I'm not going to let everyone talk about every one of them.
But I suspect that most of my colleagues who are in that boat now realize that giving jurors the ability to ask questions makes a trial better. It just always does.
Judge.
I've done it once in a trial that I thought was particularly complicated, and I persuaded the lawyers that they should allow us to do that, and I think it worked very well. Most of the time, though, I get a lot of pushback from the lawyers. They do not want me to have the jury ask questions. So I normally don't unless I think that there's some reason that we should do that.
Well, Judge Jackson?
Jurors ask questions in every case,
To your point,
if they want to.
yes, to your point, one of the things we hear from judges around the country is that I will do what the lawyers agree to. But I mean, last year I heard some judges talk on a panel discussion that the reason they don't do voir dire is that the lawyers don't want to do it anymore. They're scared of it. They don't know how to do it. This is a self-fulfilling prophecy. If the judges in this country only make changes in response to what the lawyers want to do, kiss trials goodbye. I'm telling you, that's going to happen. Because the lawyers, in the heat of battle, what's good for the other side is bad for me and vice versa. So if I suggest there be questions, the lawyer on the other side is going to say, Sussman's got something up here. He knows something here that I don't know, and he's got a trick. Okay? Any innovation. So it's very difficult to get lawyers, except the very best lawyers. Just aside, since he's here today. My whole idea to do this jury project began because I was facing judges who were not very creative in making changes. So I said, why can't the good lawyers make agreements? So for 25 years now, I've had a website called trialbyagreement.com on which I have these agreements, and I have on them now trial agreements. And 13 agreements kind of parallel these innovations. But if I suggest them to the lawyers on the other side, there's suspicion immediately. So I said, okay, I'm recognized as a plaintiff's lawyer. Who is the biggest and baddest defense lawyer in the country? It's Fred Hartman, who's here today. I said, Fred, will you take a look at these? Fred, where are you? I said, Fred, will you take a look at these? So now these agreements are not the Sussman agreements on the website. They're the Spartlett-Sussman agreements on the website. Because I figured that would give credibility to the idea that these are not pro-plaintiff or pro-defendant. These are good ideas. And being able to ask questions is one of them. So don't wait for the lawyers to come to you and say, this is a good idea. They'll never come.
Oh, they won't come, but I've raised it with them, and most of the time they say no. That this is an advocacy type of situation, and they really don't want the jurors to interfere. Even when I explain to them that if the jury is confused or still wondering about something that you passed over because you know this case inside out for 4 years, but you glossed over something, you're better off with them telling you that they are confused about it so that you can, but I get pushback. And there are things that I do tell them, we are going to do it this way in my courtroom, but that's one that I think I leave to the lawyers to decide, unless I think that there's a real reason we should have questions. But I thought it worked really well in the one case that I did do well.
Okay, so let me turn to this something that is being suggested and tried some places, but not a lot, is to allow the jurors to discuss the evidence when they are together in the jury room before final deliberations. Yes, sir?
That's also the default position in Colorado, and has been for, I'll bet there are lawyers in this room who've never practiced before that was the default position. We have a jury instruction, we read them at the beginning of the trial. You may discuss the evidence, but only when you're all together and only when you're in the jury room. But as I said, it's interesting to me that that's not.
We're a very progressive state. We have marijuana.
Perhaps even in this room, but
I hear. You know, this is amazing for me to learn, because obviously this is the place I'm going to come back to
I'll send you the instructions.
and study these innovations, because y'all are doing it and apparently doing well.
It's one of the reasons we can meet our time limits,
Yes.
because the jury is talking about the case throughout. They don't go back and their deliberations last days and days. They've already been talking about the case and issues, I'm very careful to tell them they're not finally deliberating, they have to keep an open mind. But they've gotten most of the preliminaries, I think, out of the way, and they go back and they reach a result, usually
Judge
very
Jackson, would you allow that?
No, because I think there's a potential for unfairness to the defendant. They're starting to talk when all they're talking about is the plaintiff's case. Also, Jane and I, once upon a time, worked with a jury consultant who was very, very good. And he, in his research, were that that's one thing that you really shouldn't do, is have the jurors talking to each other. They can make up their minds too early. And so I just don't do that.
I gotta say, I was glad when they changed that, added that rule, because.
They're doing it anyway.
Yeah, they did it anyway. I mean, does anybody in this room really think that, and I trust jurors, and I love jurors, but does anybody really believe that every juror, every time that they're not talking about the evidence, I'd rather give them an instruction that sets the parameters.
I believe that. I served on a 4-week jury trial, and we did not discuss it. There were times that I thought it might have been helpful, but no. I think jurors take their role very seriously, and if you have a judge who has told them that they're not supposed to, I think they follow that.
Well, I respect jurors too, Christine. I mean, I love them. Heck, they're the ones that make our job easy. But they're also human, and I was, as I said, I was glad when they changed when Colin Ford permitted.
You were in state court. Did you discuss the evidence when you were together? Do you think, I mean, I know the judge instructed you not to decide the case, not to make up your mind, keep an open mind, because you were just hearing from a few witnesses, one at a time. Were you able to follow that instruction fairly, or do you think your jury was able to discuss it without deciding?
Yes, because it was very confusing. So I think we all just sort of kept each other,
Vigilant.
right, and sort of kept up with all of the details. Because every time we would break, we would sort of go over what was said.
Okay, that's very interesting. Another practice suggested is that currently the lawyers, I forgot to ask you about this. Yesterday I heard from a judge, a federal judge, who for many years has been requiring the opening statement by the lawyers to be made before jury selection, before the questions, so that everyone who's called in the courtroom of 50 or 60 hear the complete opening statement. It's made then, not after the jury is selected. Has anyone tried that? We actually, the Civil Jury Project sent researchers to Wichita, Kansas, to test that one out, and the jurors liked it. The people who we interviewed, the people who were not selected, they seemed to like hearing about the whole case. And the lawyers liked it because they thought they got a more honest jury selection. The jurors answered better knowing what the case was about. Jackson, would you ever try that, for example?
Well, I guess I might be willing to try it, but I've never done it at the beginning. I give the jurors a pretty short but pretty good summary of what the case is about, all of them, everybody. I'm not sure that the opening statements would add that much to it for purpose of jury selection, so I've never done it.
The lawyers say it doesn't take more time and it costs more money. They make the same argument Monday morning that they would make Tuesday morning after the jury is seated. And so the other objection from one of the 4 lawyers we interviewed was that the better lawyer is disadvantaged because that identifies for jury selection the jurors who are against your position or favorable to your position, so the other one can strike them. So that there's a disadvantage in being real good in your opening statement. So how about the practice, though, of lawyers, allowing lawyers to make interim statements? Say in a 2-week trial, you have a 2-week trial, You're a complicated case.
Yeah.
Do you allow the lawyers any time to make interim statements between witnesses, like say, you've got 45 minutes, you can do it, you can use it or not, you can put it in your closing, or you can use it 5 minutes, no more than 5 minutes, between witnesses, it has to be, you can't interrupt a witness, but when a witness is on the stand, or just before they come on stand, you have to tell the jury, this is why I'm calling this next witness. I hope I call this witness, I will prove the following things. Or when you're done examining a witness, you can tell the jury, no more than 5 minutes, here's what you just heard. And I hope you all took notes of it, because it's important. And so any objections to that practice? What do the jurors think about that? Letting the lawyers talk before the end? A little.
Some attorneys just talk too much already.
Okay?
That might have been interesting, because there were a couple of witnesses that were called that we didn't really add anything. And so it would have been interesting to hear the attorney say, this is what you could have gotten out of this.
Judge Jackson, would you allow that? First, would you allow it?
Absolutely. In fact, I think any good lawyer ought to ask the judge for it if the judge doesn't volunteer it.
Right?
On a trial of any length, I always offer that. Not interim statements about what the witness just said. I'd have a real problem with that. But Monday morning of the second week, Monday morning of the third week, summarize what the evidence was from the prior week, reorient the jury to what has happened, remind them they've had a couple of days off, so that as they then get into hearing the next group of witnesses, they don't focus just on that, but they have in mind what had happened before. It has to be non-argumentative.
Right.
But any trial of any length, yeah, I understand.
How about the practice, some have suggested that what makes a lot of sense is to make the parties call their expert witnesses back to back. So the plaintiff puts on an expert, the defendant's gonna have an expert on that subject, that expert testifies next, not a week later. Judge Jackson, what do you think about that idea?
I don't like it, because I think, again, it's micromanaging the trial. But what I do tell the lawyers is, experts are sometimes hard to schedule, and you don't want them sitting around charging huge fees, waiting to be called. So whenever you want to call your expert, if there's a good reason for it, you can call the expert. You can call the defense expert in the middle of the plaintiff's case, or vice versa. I'm very flexible with that, but I'm not going to tell them when they have to do it.
Final question for the judges. Judge Gay, what do you think is the single, 2 or 3 things, most important things we can do to assure that jury trials don't disappear?
I think we need to make sure that jurors are reminded of the role that they play. And I think this is one of the things I like about what you folks are doing, because remember what we do with jurors. We ask them to resolve issues of significance between, infrequently, 2 of their fellow citizens. Very few people on earth get to do that. And I think we need to remind them of that. And what's even cooler about it, if you will, is we don't just ask them to do that, we trust them to do that. That's what, I was a trial lawyer for 25 years before I became a judge. The best part of my job is getting to talk to jurors after trials and finding out how much they enjoyed their experience, but also how well they understood the importance of what they were doing.
Will you send them to our website?
Oh, I'm gonna already ask you for a bunch of these, so I can.
We will get-
I can get them to my
We will get
colleagues.
them to you. Judge Jackson. Okay. I've got 2 more years with this project. I mean, I set with this project a time frame of 4 years. I've done 2 years. I got 2 years left. And actually, it may go on beyond 4 years unless I conclude it in 4 years. This is hopeless. It's too late to save the jury trial or all trials. So I've got to make a decision in 2 years whether I want to make this thing go on or say, goodbye, but I'll go do something else. What do you think I can do, or the Civil Jury Project can do, or anyone can do, to keep jury trials alive and well in this country? And if you don't think of it right now, you have my email address.
I think if there is a decline in jury trials, which your statistics say that there are, although personally.
You're different.
But if there is, part of it, of course, is the cost of litigation. It's a boring topic. It's a topic for another day. But that's part of it, and there are ways to tackle that I think the system hasn't done. The second part is a culture. There's a culture, I think, especially in the big firms, of being a litigator means churning out motions, taking depositions, and not trying cases, and that propagates itself. And the way to save it or turn it around is to really convince the new lawyers who are eager beavers that it is important to go to court and to bring them to court and to give them opportunities to have witnesses and things like that.
Will you, let me ask you a question then. I have gone around and a lot of judges, at least 15 or more judges now have a young lawyers rule that they are proposing on motions, which says that it's important to the court that young lawyers get trained. And if you will notify the court that you have a lawyer who's 5 years or under in practice is going to argue the motion, you will get an oral argument, which is unusual in federal court. I mean, you frequently rule out papers. And the court rule, but there are 15 versions and there are different ways of defining the young lawyer's rule. But I want to take it a step further and say that you will notify the court that a young lawyer is going to be lead counsel, meaning address the jury directly in opening, closing, cross-examining, putting all witnesses. Lead counsel in the case, you will get a preferential say. Okay, how about that? You want to do something to train us? How about that, Judge?
It's a bad idea. The reason it's a bad idea is because you're potentially exposing the law firm to a complaint from its client that they wanted to pay for Sussman and they got McGahee.
Let me give you another shot.
People even said that after I've been in practice.
Professor Sussman, I think it's a bad idea also because we shouldn't favor one set of litigants over the other for any reason. And so I would not be inclined to do something like that. I would be inclined to go ahead and set matters for hearing if they wanted to get that experience to a young lawyer. But I don't think it's good to show preferential treatment in that way.
Judge Jones, what should we do at the Civil Jury Project over the next few years? What do you think we could do other than having lunches like this to keep jury trials alive and well?
Convince the bar that the belief in irrational runaway juries is a bunch of baloney. Jurors who come in and they're conscientious, they want to do a good job, they pay attention, they bring to the resolution of the dispute differing views that meld together and having in a verdict that is reflective of everything positive about our system and our system of justice. And as long as attorneys are aware of that and can tell their clients that, then there's a reason to go to a jury trial. But if you're fearful, fearful that either they're irrational or you can't pull the wool over their eyes, because you can't, very seldom, then that's why you wouldn't want a jury trial. But otherwise, if you convince the bar that that microcosm of our society is a good way to resolve your dispute, that you can't resolve on your own, people will
Well, I
practice
can-
to a jury.
I can convince the bar easily, but I need to convince the bench not to grant summary judgment.
I was just gonna say that. I was just gonna say that the easiest way is just deny all dispositive motions.
Well, is,
That's not really right either,
is
because
denial of
then.
dispositive motion reversible?
Oh,
It's
yeah.
not even appealable. Why not?
No, denial isn't, but then that's unfair to, if it's the defendant that filed the motion for summary judgment, and I just deny it without really looking at it, that's
Take it with
unfair
the
to them
carrot
because of
with
the
the cake.
experience. It's the experience, I'm sorry, the money and the investment that they have to make to go to trial on a case that perhaps should have had summary judgment granted. But that is, and if you really want to get a large number of trials, you just deny motions for summary judgment.
To tell you we did at 1:30, and we will end at 1:30, and, because it's that right now, I want to thank the jurors for coming and participating today, and I want to thank the judges for coming and being on this panel. What I have learned is, first place, a lot of things today. The judges are much more receptive to doing good things than we give them credit for. Frequently, I hear a lawyer in the case on the other side say, I do that, but that's not the way Judge Jones operates. I'm sorry. He will never allow us to do that. So that's bull to begin with. You've heard people up here express willingness to try things, listening to what other people are doing, and so you lawyers work together to do creative things to make the system better. And I really appreciate the judges. We videotape these, I think we are videotaping this, we videotape each one of these lunches. They are available on our website so people can go to them. Because what we have learned is that judges who are even in the same courthouse don't know what's going on in the chambers next door. And certainly not in the courthouse across the street. And certainly not in the courthouse across the country. And if we can somehow get the discussion going about these innovations and about what works and doesn't work, there will be more interest in trying jury cases. Thank you very much for being here, and thank you.